June was a chilling month on death row. From last meals to final words, these are the people that were executed and the crimes that put them there. Gregory Hunt, June 10, Alabama. On August 2, 1988, Karen Lane was brutally murdered in the apartment she shared with Tina Gilliland, located at 105 Elliott Heights in Cordova, Alabama. Lane had been dating Gregory Hunt, Gilliland's cousin, for approximately 1 month prior to her death. On the afternoon of August 1, 1988, Hunt was at the apartment with Lane when Gilliland's ex-husband arrived with his fiancée, Shirley Romine, to pick up his and Gilliland's 2 children. Gilliland was taking a nap at the time. According to Romine, after Lane left the room, Hunt expressed frustration, stating he was tired of everything and planned to move back to Miami, Florida. He also said, "She makes me so mad I could kill that bitch." When Gilliland woke up around 6 p.m., Hunt was gone. Shortly after, Gilliland and Lane left in Gilliland's beige 1986 Yugo. After stopping to buy cigarettes, they went to the residence of Gilliland's then-fiancé, Clinton Cook, in Parrish, Alabama. Upon arrival, around 7 p.m., they saw Hunt's van outside. Gilliland entered the residence while Lane left in the Yugo. Inside, Hunt noticed Lane in the Yugo and asked Gilliland why Lane didn't get out of the car. Gilliland replied that Lane had gone to her mother's home. Hunt then left. Later that evening, Hunt visited the home of James Molinex and Hortensia Ovalle in Jasper, Alabama, arriving around 8 or 8:30 p.m. While there, Hunt discussed his frustration with Lane, stating he needed to do something about the problem. As he left, he said he was going to f somebody up. Returning to Cordova, Hunt called Cook's residence around 9:40 p.m. from his mother's home at 405 2nd Street. He asked Gilliland where Lane was. Gilliland told him Lane said she was going to her mother's home. Hunt warned, "I know how you women are. You better tell me where she's at." When Gilliland replied she didn't know, Hunt insisted, "You better tell me where she's at or it is going to be detrimental to you." He added he was ready to go back to prison if necessary. Later that night, Lane's father, W.O. Sanders, discovered that a house Lane had previously occupied was on fire. Sanders, who lived about 200 yards from that house, testified he heard Hunt's van pass his house twice that night. After the second pass, he discovered the fire. After calling Gilliland and driving by Sanders' house, Hunt returned to Jasper. When Deborah Twilley returned home from work at 11 p.m., Hunt was there using her telephone. Twilley noted Hunt appeared to have been drinking. He asked to borrow her car, explaining, "I've got some stuff I need to do. It's not wise that I'm seen in my van." After Twilley refused, the conversation turned to Lane. Hunt said he was tired of her and admitted to burning her house, stating he poured gas on it and set it on fire. He asked Willie to drive him to Cordova to check if the house had burned down completely, expressing hope that it had. Around midnight or 12:30 a.m. on August 2, Amy Cherie Long saw Hunt in his van chasing Lane, who was driving the beige Yugo at high speed in Cordova. Hunt then returned to his mother's home and called Cook's residence at 12:55 a.m., speaking with Cook. Hunt said something had happened materially and that Karen's family and Karen would be upset with him because of what he had done. He stated he would have to move back to Florida, but added people didn't screw him over like this and get away with it. Around 1 a.m., Hunt called Lane's mother, Betty Jo Sanders, asking if Karen was there. When Sanders said no, Hunt mentioned Karen's house had burned and that she would be hurt because she loved that place. He also said he had been looking for Karen, stating she was running stop signs and lights, and all he wanted to do was say hi to her, but she wouldn't stop. Hunt also threatened violence against Gilliland, saying, "You know, Tina is scum. I'm going to throw her up against the wall, do you know what I mean? I won't do to mess with. I grew up in violence. I know what it's all about." Shortly before 2 a.m., Mary Turner, who lived at 103 Elliott Heights, in an apartment separated from Gilliland's by one other apartment, heard a noise that sounded like glass breaking. She saw Hunt reach his hand into the window of Gilliland's apartment and then entered through the adjacent door. After Hunt entered, Turner heard peculiar noises, one that sounded like somebody had hit the floor hard and another like someone sliding a chair across the floor. Around 2 a.m., she heard the door slam and saw Hunt leaving the apartment. At 2:44 a.m., Cook received another call from Hunt, who was calling from Gilliland's apartment. Hunt told him that Karen was lying there in the kitchen floor and asked Cook to get somebody up there to get her to the hospital. Karen Lanes' body was discovered in Gilliland's apartment later that morning. After calling Cook, Hunt returned to Jasper. Molinax and Ovalle testified they found Hunt's van outside their home around 6 a.m. According to Molinax, Hunt was in the van and, as Molinax left for work, he raised up a little bit and then went back down. Later that day, Hunt drove to Cullman, Alabama, to Jack and Jean Kilpatrick's house. From there, around 7 or 8 p.m., Hunt called his brother-in-law, Russell Davenport, in Cooper City, Florida. Hunt said he had been out partying with a woman and got into a fight with her. He stated, "I don't think I killed her. I'm not sure how she was when I left her. I checked with the hospitals and newspapers, and I can't find anything else about her at all." Hunt was arrested later that month. In October, his sister, Loretta Martin, visited him in jail. Martin testified they discussed Karen Lanes' death. During their conversation, she asked Hunt, "You did kill her?" Hunt said, "Yes, I did." He explained they had a fight on the night of her death. He hit her, lost his head, and couldn't control himself. Hunt told Martin he had gone out looking for Lane and chased her through Cordova. When Martin asked if he had been drinking, he said he had been drinking and taking some medication prescribed by a doctor. In June 1990, while detained in jail pending trial, Hunt also confessed to his cellmate James Carr Sanders. Sanders testified Hunt said he and Lane had fought because she was dating someone else. He had knocked her down, choked her, kicked her, and inserted a broomstick into her private area. After that, he saw she was bleeding, became scared, and called the police. Dr. Joseph Embry, who performed the autopsy, testified Lane sustained approximately 60 injuries, including about 20 to the head. Her injuries included lacerations, external bruises, bruises to the brain, fractured cheekbones, nasal bones broken into small pieces, 12 rib fractures on each side, a fractured breastbone, bruises to her heart and lungs, a bruised pancreas, a 3/4-inch tear in her aorta, and 3 tears in her liver. She also had bleeding in the muscles in her neck and numerous bruises and lacerations on her arms, legs, chest, and back. Larry Hughes, a serologist with the Alabama Department of Forensic Sciences, analyzed swabs from Lane's private parts and mouth. The oral swabs revealed Lane's mouth contained genetic material. Hughes stated that quantity and condition of the material suggested that it was deposited very close to the time of the death, if not post-mortem. Gregory Hunt, 65, was pronounced dead at 6:26 p.m. at a South Alabama prison on June 10. He was executed by nitrogen hypoxia. An inmate is forced to breathe pure nitrogen gas throughout the execution process, depriving them of oxygen, which is essential for survival. Hunt, strapped to a gurney and wearing a blue-rimmed mask that covered his face, did not offer any last words, but seemed to use his fingers to make the thumbs up and peace signs. It was unclear exactly when the gas started to flow, but it started after 5:55 p.m. At 5:57 p.m., Hunt jerked, gasped, and lifted his head off the gurney for a moment. At approximately 5:59 p.m., he moaned and raised his legs. After 6:05 p.m., he stopped moving and took 4 or more gasping breaths with extended intervals in between. The gasps and trembling motions were similar to earlier nitrogen executions in Alabama. Critics claim that, although the state maintains that the motions are expected, they demonstrate that the execution procedure does not guarantee a speedy death. A number of Lane's family members were present at the execution. Hunt was one of the death row inmates in Alabama with the longest sentence. Last month, he told the media that he wanted to help other prisoners and that discovering religion in prison helped him become free of his demons. Since 1998, he has been teaching a weekly Bible class. Hunt refused his final dinner tray, which included hot dogs, vegetables, potatoes, and black-eyed peas. However, earlier that day, he was served a lunch tray containing bologna, black-eyed peas, carrots, and fruit punch. On the same day, but in another state, another inmate faced his death. Anthony Floyd Wainwright, June 10, Florida. On April 27, 1994, Carmen Gay Hart, a 23-year-old nursing student and mother of 2 children, was abducted in Lake City, Florida. Born on September 2, 1970, Gay Hart had been working towards her nursing degree while also raising her young children. That day, she vanished without a trace, setting off a series of events that would later shock the state. The individuals responsible for her disappearance were Anthony Floyd Wainwright, born October 22, 1970, and Richard Eugene Hamilton, born February 16, 1963. Just a few days before the crime, both men had managed to escape from a prison facility in North Carolina. Carmen was declared missing when she failed to arrive at her children's daycare to pick them up, something that was extremely out of character for her. At the time, she was attending nursing classes at Lake City Community College and was last observed in a parking lot not far from campus earlier that day. Her failure to collect her kids immediately raised alarm among her loved ones. Her husband, her father, and classmates began a frantic search for her, but when their efforts yielded no leads, she was officially reported missing. Unbeknownst to them, Carmen had already been abducted at gunpoint by Wainwright and Hamilton. She had just finished loading groceries into the Ford Bronco she had been driving in the parking lot of a Winn-Dixie store when the two escapees targeted her. Just 2 days prior to this horrifying incident, Wainwright and Hamilton had broken out of a minimum security facility in Carteret County, North Carolina. Wainwright had been serving a 10-year sentence for burglary, while Hamilton was serving a 25-year term for armed robbery. After their escape, they stole a vehicle and broke into a home where they obtained 2 rifles. Armed and on the run, the men fled southward into Florida, where they ultimately encountered and abducted Carmen Gayhart. After capturing her, the 2 men ditched their original stolen vehicle at a lumber yard along U.S. Route 41. They then took off in Carmen's Ford Bronco with her still alive in their custody. They transported her to a secluded forested area located behind the Fuel City truck stop off State Route 6 in Hamilton County, Florida. Hidden away from view in a remote and isolated location, they subjected her to a violent and degrading essay. According to Richard Hamilton's later testimony, Wainwright attempted to strangle Carmen following the assault. To ensure she was dead, Wainwright then shot her twice in the head using a bolt-action .22 caliber rifle, killing the young mother. After leaving her body in the woods, the pair fled, continuing their attempt to escape capture. During court proceedings, each man accused the other of being the one who strangled and shot Carmen. The next day, on April 28, 1994, the 2 fugitives were located in the vicinity of Brookhaven, Mississippi. When approached by a state trooper from the Mississippi High Patrol, Wainwright and Hamilton opened fire, resulting in a shootout. Both suspects were wounded but survived their injuries. Hamilton was shot in the face, while Wainwright sustained a gunshot wound elsewhere. At the time of their arrest, they were still driving the Ford Bronco that had belonged to Carmen Gayhart. However, despite recovering the vehicle, authorities had yet to find any trace of Carmen herself. Following his arrest, Hamilton waived his right to contest extradition and was quickly returned to Columbia County, Florida. Once back in Florida, he underwent an extensive interrogation by detectives from the Columbia County Sheriff's Office regarding Carmen's disappearance. During this interrogation, Hamilton confessed to the crime and offered detailed information about what had occurred. He even went so far as to sketch a map identifying the location where they had taken Carmen, essayed her, attempted to strangle her, and ultimately shot her. However, despite drawing the map, Hamilton was unable to specify the exact city or county where the crime took place. In his statement, he admitted that both he and Wainwright had taken part in the essay, but claimed that Wainwright alone had committed the actual murder by shooting Carmen. On May 2, 1994, Tina Wheeler, a dispatcher with the Hamilton County Sheriff's Office, recognized the area depicted on Hamilton's map as being near State Route 6. Acting on this tip, Deputy Sheriff Mel Black and Albert Jones traveled to the identified area around 4:30 in the morning to search for Carmen's body. During their search, Jones noticed a strong foul odor and notified the investigators. As the sun rose at around 7 a.m., authorities discovered Carmen's decomposing remains. The case was officially taken over by the Hamilton County Sheriff's Office, and her body was sent to the District 4 Medical Examiner's Office in Jacksonville for further analysis. After the body was transported, a more detailed search of the crime scene was conducted. Dr. Margarita Arruza, the medical examiner overseeing the case, observed that several of Carmen's teeth and her hyoid bone were missing. Based on her findings, she advised law enforcement to revisit the crime scene. Following this recommendation, investigators returned and were successful in recovering some of the missing teeth as well as the hyoid bone, critical in corroborating evidence of strangulation. In the weeks following their arrest, both Wainwright and Hamilton were formally charged with a series of serious felonies, including first-degree murder, sexual battery, robbery, and kidnapping. In July 1994, a grand jury indicted both men on all counts. The state attorney for Florida's 3rd Judicial Circuit, Jerry Blair, announced that the state would pursue the death penalty, citing the particularly brutal and premeditated nature of the crimes, along with the aggravating circumstances such as the essay, kidnapping, and Carmen's vulnerability. The case drew substantial public interest as the horrifying nature of the crimes generated widespread outrage. Carmen's family made it known that they supported the pursuit of capital punishment for both men. Due to the extensive media coverage and difficulty in assembling an impartial jury in Hamilton County, the court opted to move the trial to Clay County, where a jury was more easily seated. While they were held at the Clay County jail awaiting trial, both Hamilton and Wainwright repeatedly expressed a desire to escape. Authorities received intelligence indicating that the pair was actively plotting a breakout that allegedly included a plan to murder a correctional officer during their attempt. Given the seriousness of these threats, both men were moved to maximum security cells, and additional precautions were taken. During court appearances, stun belts were fitted to both inmates and kept activated to ensure control and prevent any violent outbursts or escape attempts. The separate trials for both men began in May 1995. On May 30 of that year, both juries returned guilty verdicts against Hamilton and Wainwright for the kidnapping, essay, and murder of Carmen Gayhart. Just 2 days later, on June 1, 1995, both juries recommended the death penalty. The jury in Wainwright's case was unanimous in their decision, while Hamilton's jury returned a 10-2 majority in favor of execution. On June 12, 1995, Circuit Judge Vernon Douglas sentenced both men to death in the electric chair. In addition to their death sentences, the judge handed down 3 consecutive life terms each for the additional crimes committed against Carmen. Hamilton's direct appeal to the Florida Supreme Court was rejected on October 23, 1997. His second appeal, filed in 2004, was also denied. On March 3, 2017, his petition to a writ of habeas corpus was rejected, and on February 8, 2018, his final post-conviction appeal was turned down, confirming his death sentence. Wainwright's direct appeal was similarly dismissed by the Florida Supreme Court on November 13, 1997. His subsequent appeal in 2004 was also denied. On November 13, 2007, the U.S. Court of Appeals for the 11th Circuit rejected his case, and in 2008, the Florida Supreme Court dismissed the third appeal. Most recently, in July 2023, the 11th Circuit again rejected Wainwright's latest appeal, which included new DNA evidence. The court ruled that the DNA findings did not effectively counter the trial evidence or demonstrate Wainwright's innocence. On January 13, 2023, Richard Hamilton died at the age of 59 while incarcerated at Union Correctional Institution in Florida. He had spent roughly 28 years on death row. The Florida Department of Corrections did not release a cause of death. Following his passing, Wainwright remained the sole surviving perpetrator of the 1994 crime. On May 10, 2025, Florida Governor Ron DeSantis signed Wainwright's death warrant, setting the execution date for June 10, 2025. Anthony Wainwright, 54, received a lethal injection at Florida State Prison. Around 6:10 p.m., the execution got underway. At 6:14 p.m., Wainwright's shoulders trembled a few times, and he blinked and inhaled deeply before going motionless. Gayhart's husband, son, and mother-in-law were among the 17 family members who witnessed Wainwright's death at 6:22 p.m. Wainwright did make a final statement, but it was inaudible from the witness room. On the morning of his execution, he was offered a special last meal, but he politely declined, opting only for the regular prison breakfast. 2 days later, John Hansen was executed in Oklahoma. On the evening of August 31, 1999, a horrifying sequence of violent crimes unfolded in Tulsa County, Oklahoma. 2 men, George John Hansen, also known by the alias John Fitzgerald Hansen, and Victor Cornell Miller, embarked on a crime spree that included the carjacking and the brutal murder of a 77-year-old woman, as well as the cold-blooded killing of a man who had the misfortune of witnessing their criminal activity. That same evening, Mary Agnes Bowles, a 77-year-old retired banker from Tulsa who had once served as president of the St. Francis Hospital Auxiliary, became a victim of Hansen and Miller. She had been at the parking lot of the Tulsa Promenade Mall when the two men abducted her. Earlier that day, the duo had already committed 2 liquor store robberies and were actively looking to expand their crime spree. They targeted Bowles specifically for her vehicle, intending to use it to carry out additional robberies. During the abduction, Miller took control of the driver's seat while Hansen held Bowles at gunpoint in the back seat as they drove away from the mall. Their journey took them to a dirt pit near the town of Owasso, a location owned by Gerald Max Thurman, a 44-year-old businessman who operated a trucking company in the area. By coincidence, Thurman was on site making a delivery when he noticed a suspicious vehicle, Bowles' car, repeatedly circling the pit. Concerned, he made a phone call to his nephew to report what he had observed. Tragically, moments after the call, he encountered the man. In an attempt to eliminate him as a witness, Miller approached Thurman and shot him 4 times with a revolver, leaving him critically wounded. While this was happening, the pair continued on with Bowles in the car. Eventually, they pulled over at a roadside location. There, Hansen forced Bowles out of the vehicle and mercilessly shot her multiple times, between 4 and 6, using a semi-automatic handgun. She was killed instantly. After the murder, Hansen and Miller tried to conceal her body by covering it with branches before fleeing the area. Thurman's shooting did not go unnoticed. Nearby individuals who heard the gunshots alerted authorities, leading them to discover Thurman's location shortly after the incident. Although he was still alive when found and rushed to a hospital, he succumbed to his injuries 2 weeks later, on September 14, 1999. Bowles, on the other hand, was not discovered until a week after her abduction. Her body was found on September 7, 1999. In the days that followed, law enforcement launched an intensive investigation. On September 9, 1999, Hansen and Miller were arrested at a local motel. Their arrest was initially for a separate crime, a robbery committed the day prior, on September 8, at a federal credit union. As police continued to investigate, they soon linked the two men to the murders of both Bowles and Thurman. Forensic analysis revealed their fingerprints on Bowles' vehicle, and investigators discovered a revolver, along with a 9mm semi-automatic pistol wrapped in plastic hidden inside the vehicle's gas tank. These were identified as the weapons used in the killings. The evidence led to formal charges against both men for the murders. Additionally, Hansen and Miller faced multiple federal robbery charges for crimes committed before and after the murders. George Hansen stood trial first. His criminal history included prior convictions dating from 1983 to 1990 for robbery and assault. In May 2001, he was tried separately for the first-degree murders of Gerald Thurman and Mary Bowles. After a nearly 5-hour deliberation, a jury in Tulsa County found him guilty of both murders on May 18, 2001. Prosecutor Tim Harris sought the death penalty in the case. A few days later, on May 23, the jury returned with their sentencing recommendations: the death penalty for Bowles' murder and life imprisonment without the possibility of parole for the murder of Thurman. Despite having received a death sentence, Hansen was not transferred to Oklahoma's death row. Instead, due to his involvement in separate federal robbery cases, he remained in federal custody. He was ultimately sentenced to life in prison for the federal charges and was housed at the United States Penitentiary in Pollock, Louisiana. Victor Miller, Hansen's accomplice, was tried separately following Hansen's trial. Miller had a violent criminal past as well. In 1981, he had been convicted of first-degree murder in another case and received a life sentence, along with 3 30-year terms for armed robbery, which were to be served concurrently. That earlier conviction was later reduced to second-degree murder, and Miller was released in 1997, just 2 years before the Bowles-Thurman murders. Like Hansen, he also faced federal charges for unrelated robberies and was sentenced to life in federal prison. He was then extradited back to Oklahoma to stand trial for the double homicide. On April 17, 2002, a separate Tulsa County jury found Miller guilty of both murders. 2 days later, on April 19, he was sentenced to death for Mary Bowles' murder and life without the possibility of parole for Gerald Thurman's. George Hansen's legal journey continued. On June 11, 2003, the Oklahoma Court of Criminal Appeals overturned his death sentence and ordered a resentencing trial. That new sentencing phase took place from January 9 to January 24, 2006, and once again, Hansen received the death penalty for the murder of Bowles. In April 2009, his appeal was dismissed. Appeals to higher courts followed, all of which were denied. The U.S. District Court for the Northern District of Oklahoma rejected his appeal in July 2013, the 10th Circuit Court of Appeals denied it on August 13, 2015, and the U.S. Supreme Court followed suit on May 16, 2016. Even as recently as September 10, 2021, another appeal was rejected. Hansen was one of 28 Oklahoma death row inmates who filed a lawsuit challenging the constitutionality of the state's execution procedures. However, in June 2022, the lawsuit was dismissed when the court ruled that Oklahoma's execution protocols did not violate constitutional protections. Meanwhile, Victor Miller pursued his own appeals. In 2004, the Oklahoma Court of Criminal Appeals overturned his convictions and sentences, granting him a new trial. That retrial took place in November 2008, during which he was again convicted on both counts of first-degree murder. This time, the jury recommended 2 death sentences. On December 9, 2008, Judge Dana Keown formally imposed both death sentences. However, Miller's legal saga did not end there. In 2013, the Oklahoma Court of Criminal Appeals heard his appeal and determined that one of his death sentences should be commuted to life without parole, while the other sentence should be overturned and subjected to another resentencing hearing. By November 2015, before the resentencing trial could proceed, Tulsa County prosecutors announced they would no longer pursue the death penalty in his case. As a result, Miller was handed a second life sentence without parole. As of 2025, he remains incarcerated at the Oklahoma State Reformatory. As Hansen exhausted all of his appeals by 2016, he remained on federal death row at USP Pollock. A 2020 report indicated he was one of 26 inmates in Oklahoma eligible for execution, having no remaining legal challenges. However, at that time, executions in the state were paused due to a series of mishandled executions, including a botched one in 2014 and 2 serious drug mix-ups in 2015. The state resumed executions in October 2021. On July 1, 2022, the Oklahoma Court of Criminal Appeals set execution dates for 25 death row inmates whose appeals had been exhausted. George Hansen's execution was initially scheduled for December 15, 2022, with a clemency hearing set for November 9 of the same year. Oklahoma officials requested the federal government to transfer Hansen to Oklahoma's custody to carry out the execution, but the request was denied. It was believed that this refusal may have been influenced by the Biden administration's moratorium on federal executions, although no official reason was confirmed. Subsequently, Oklahoma Attorney General John O'Connor filed a lawsuit against the Federal Bureau of Prisons for refusing to hand over Hansen. On December 13, 2022, U.S. District Judge Reed O'Connor ruled against the state, stating that the Bureau of Prisons had broad discretion in matters involving public interest and that the federal government could decline to authorize a transfer. As a result, Hansen's execution was indefinitely postponed. After Donald Trump was inaugurated as U.S. President on January 20, 2025, Oklahoma Attorney General Getner Drummond promptly reapplied for Hansen's transfer on January 23. The move was backed by an executive order signed by Trump directing the Department of Justice to resume capital punishment enforcement. Drummond criticized the prior administration's decision, calling it the epitome of subverting and obstructing the execution of a capital sentence. On February 13, 2025, newly appointed U.S. Attorney General Pam Bondi approved the request, allowing Hansen's transfer to proceed. By March 3, 2025, Hansen was moved to the Oklahoma State Penitentiary, the designated facility for housing death row inmates. On April 1, 2025, the Oklahoma Court of Criminal Appeals set his execution date for June 12, 2025. In the wake of this announcement, Jake Thurman, the son of Gerald Thurman, spoke publicly about the emotional weight of the long wait. He expressed a mix of relief and sorrow, stating that justice was finally being served after nearly 3 decades. He described his father as his hero and friend, adding that his children bore a strong resemblance to their grandfather, which kept his memory alive. Jake also shared how devastated he and his mother were when Hansen's execution was stayed in 2022. Tragically, his mother passed away less than 2 months later due to organ failure. Though he expressed disappointment that Miller had not received the death penalty, Jake also said he had made peace and forgiven both men. A clemency hearing was held for George Hansen on May 7, 2025. His legal team appealed for a commutation of his sentence to life without parole. Oklahoma Attorney General Drummond, however, strongly opposed any form of clemency. He urged the Pardon and Parole Board to reject the plea, stating, "This murderer's execution has been delayed for far too long. I am committed to ensuring that the Bowles family finally sees that justice is done for their loved one." On May 7, 2025, the Oklahoma Pardon and Parole Board, in a narrow 3-2 vote, officially denied the request for clemency. At 10:11 a.m., John Fitzgerald Hansen, 61, was declared dead after receiving a lethal injection of 3 drugs at the Oklahoma State Penitentiary in McAlester. At 10:01 a.m., the execution got underway. At 10:06 a.m., the doctor entered the execution chamber and declared him unconscious after the deadly medicines started to flow. Hansen could be heard snoring when the Department of Corrections Chief of Operations announced he was unconscious. For his final meal, he didn't ask for anything special. He did receive the same meals as the other prisoners: carrots, 2 rolls, 2 fruit cups, and chicken pot pie. His last words were, "Just forgive me. Peace to everyone." Stephen Stanko, June 13, South Carolina. Stephen Christopher Stanko, born on January 13, 1968, at the Guantanamo Bay Naval Base in Cuba, was convicted for a brutal series of crimes committed in 2005, which included the cold-blooded murders of 2 individuals, as well as the kidnapping and essay of a teenage girl, the daughter of one of his murder victims. Stanko's criminal background predates these murders. In 1996, he was incarcerated after being convicted of assault and kidnapping. He served 8.5 years of a 10-year sentence before being released from prison in 2004. During his time behind bars, he co-authored a book titled Living in Prison: A History of the Correctional System with an Insider's View. This work was written during his first prison stint and offered both a historical and personal account of the correctional system in the U.S. Upon release, Stanko was described by those who encountered him as an articulate, intelligent, and well-spoken former inmate. He appeared to be a reformed man who was open about his criminal past and often discussed the time he spent in prison, as well as the book he had written. He moved to Myrtle Beach, South Carolina, shortly after being released and rented a room where he stayed for nearly a year. His parole officer took measures to ensure transparency and confirmed that the landlady was aware of Stanko's criminal background, something Stanko himself disclosed when applying for the room. During this period, he kept a low profile. Although occasionally late with rent payments, he caused no significant trouble. He frequently lamented the difficulties he faced in securing stable employment due to his criminal record. Over the course of the year, he held 1 or 2 short-term jobs, though none lasted. Eventually, he vacated the rental property abruptly and moved in with a friend, offering to look after her elderly mother in exchange for room and board. Roughly 1 year after his release from prison, Stanko began spending time at a local library under the pretense of conducting research for a second book. It was during this time that he became acquainted with Laura Ling, a librarian who worked there. Their relationship grew, and eventually, Stanko moved in with Ling as her romantic partner. He also struck up what appeared to be a friendly rapport with another regular library patron, 74-year-old Henry Turner. However, beneath the surface of this seemingly stable post-prison life, Stanko was preparing for a spree of violence that would shock the community. In April 2005, he carried out a series of horrific acts. He strangled 43-year-old Laura Ling to death, shot Henry Lee Turner in a fatal attack, and then essayed and violently attacked Ling's teenage daughter by slitting her throat. Miraculously, the young girl survived her injuries and managed to place a 911 call that would lead to the unraveling of Stanko's crimes. Following a highly publicized trial where his defense team attempted to argue insanity, Stanko was convicted on multiple counts. On August 18, 2006, a jury in Georgetown County found him guilty of the murder of Laura Ling and sentenced him to death. In addition, he received a prison sentence of 110 years for the related crimes committed against Ling's daughter, included criminal sexual conduct, kidnapping, and armed robbery. In a separate trial in November 2009, related to the murder of Henry Turner, Stanko was again found guilty. This time, a jury in Horry County handed down a second death sentence. When law enforcement officers searched his residence, they discovered numerous articles and materials about infamous serial killers such as Jeffrey Dahmer and Gary Ridgway, the so-called Green River Killer. This led police to speculate that Stanko had either a strong interest in serial killers or was potentially attempting to become one himself. Following the brutal attacks, a nationwide manhunt ensued. A reward of $10,000 was offered for any information leading to Stanko's capture. Thanks to tips from the public, he was eventually located and apprehended without incident by the U.S. Marshals Service in Augusta, Georgia. At the time, Stanko had been hiding in the Augusta area, blending in during the annual Masters tournament, which attracts large crowds, making it easier for him to remain inconspicuous. Stanko's appeals process began on September 23, 2007, when he made his first appearance before the South Carolina Supreme Court. His legal team aimed to overturn the death penalty verdict he received for the murder of Laura Ling. They argued that the original trial had been flawed, claiming the trial judge had improperly barred the defense from questioning prospective jurors about their views on the insanity defense. Moreover, they contended that the court did not permit them to present evidence about Stanko's age or mental state as mitigating or aggravating factors. Despite these arguments, the South Carolina Supreme Court ultimately upheld both the conviction and the sentence. Years later, in February 2013, Stanko suffered another legal defeat when the South Carolina Supreme Court affirmed his conviction and death sentence in the case of Henry Turner's murder. Following this, in 2015, Stanko sought post-conviction relief through another legal process known as a PCR hearing. During this proceeding, his former trial attorney, Bill Diggs, testified that Stanko suffered from a brain defect that may have influenced his behavior. Despite this testimony, on May 24, 2016, the court upheld the conviction and denied Stanko any form of relief. Stanko's final hope rested with the highest court in the country. However, on May 5, 2025, the United States Supreme Court denied his petition. According to 15th Circuit Solicitor Jimmy A. Richardson II, this denial meant that all legal appeals related to the murder of Henry Turner had been exhausted. As a result, the South Carolina Supreme Court was authorized to issue an execution notice. Execution notices in South Carolina are typically issued on Fridays in accordance with state procedures. This scheduling method ensures that the execution is carried out on the fourth Friday after the notice is issued, allowing adequate time for any last-minute legal interventions. In Stanko's case, the official notice of execution was issued on Friday, May 16, 2025, the first Friday available following the May 5th court decision. The preceding Friday, May 9, had been a state holiday, Confederate Memorial Day, during which the Supreme Court was closed. The execution of Stephen Stanko had been scheduled for June 13, 2025. He was given until May 30 to choose the method of his execution. Under current South Carolina law, death row inmates are permitted to select between three methods: electrocution, lethal injection, or a firing squad. Reacting to the long-awaited execution notice, the son of Henry Lee Turner expressed a sense of resolution. He publicly stated that he intended to be present for the execution and remarked that, in his opinion, it should have taken place many years ago. He remembered his father fondly, describing him as a cheerful, kind-hearted individual who was a loving and devoted parent. In the days following the announcement of his execution date, Stanko submitted a formal request to the state seeking more information regarding its protocols for both lethal injection and execution by firing squad. He initially indicated a preference for the firing squad. However, after reading published details about the recent execution of inmate Mikal Mahdi, he reconsidered. Ultimately, the South Carolina Supreme Court rejected his request for more information on May 29, 2025. On June 13, Stephen Stanko, 57, was pronounced dead at 6:34 p.m. Following a farewell statement that lasted 3.5 minutes, during which Stanko apologized to his victims and requested that they not judge him based on the worst days of his life, the execution got underway. In contrast to earlier executions, witnesses could hear prison officials requesting the first dose of the sedative pentobarbital. Stanko seemed to be speaking as he turned to face the victims' families and then quickly exhaled as his lips trembled. After a minute, Stanko seemed to stop breathing. The color drained from his cheeks and hands and his vibrant complexion vanished in an instant. 13 minutes later, a prison staff member requested a second dose of pentobarbital. About 28 minutes after the execution began, he was declared dead. Until long after Stanko's respiration ceased, 3 of the victims' relatives continued to stare at him. Stanko's lawyer and brother also observed. For his last meal, he chose fried fish, fried shrimp, crab cakes, a baked potato, carrots, fried okra, cherry pie, banana pudding, and sweet tea. His final words were, "Once I am gone, I hope that Christina, Laura's family, and Henry's family can all forgive me." The execution may help them. Forgiveness will heal them. Thomas Lee Goodinas, June 24, Florida. On the evening of May 23, 1994, Thomas Goodinas, along with 3 of his roommates, made their way to Barbella's bar located in Orlando, Florida. They arrived sometime between 8:30 and 9 p.m. Before reaching the bar, the group had already consumed alcohol and Mary Jane, drinking beer and smoking both at their shared apartment and again inside the car during their drive to the bar. Their substance use didn't stop there. Throughout the night, as they continued drinking, the group would periodically step outside to their vehicle to smoke some more Mary Jane. By the time the bar closed at 3 a.m., Goodinas was missing. One of his roommates later testified that the last time he saw him was around 1 a.m., but after that point, no one in the group knew where he had gone. That same night, Rochelle Smith and her fiancé also visited Barbella's, arriving between 11 and 11:30 p.m. After enjoying their time there, they decided to leave at approximately 2 a.m. However, Smith mistakenly walked to the wrong parking lot. It was there that she noticed a man crouched behind another vehicle, observing her. This man was later identified as Thomas Goodinas. Realizing her mistake, Smith walked over to the correct parking lot where her car was actually located, but she couldn't shake the feeling that someone was following her. Acting on instinct, she quickly got into her car and locked all the doors. Her fears were confirmed when the same man she had seen earlier suddenly approached her car. First, he tried to open the passenger side door. When that failed, he attempted to smash the driver's side window while shouting at her in a threatening and sexually aggressive manner, reportedly yelling, "I want to f*** you." Smith began sounding her car horn in a panic, which eventually caused Goodinas to flee the scene. Later on, she positively identified him from a police photo lineup as the man who had tried to assault her that night. The night took an even darker turn. Michelle McGrath was last seen alive at Barbella's at about 2:45 a.m. Like Smith, McGrath had parked in the same lot where Goodinas had been lurking earlier. Tragically, her body was discovered the next morning, on May 24, 1994, by an employee of Pace School located near the bar. Her lifeless body had been dumped in an alley adjacent to the school. The medical examiner estimated her time of death to be sometime between 3 and 5 a.m., indicating she died shortly after she was last seen. When her body was found, it was completely naked except for her bra, which had been pushed up above her chest. McGrath had suffered multiple severe injuries, including blunt force trauma to the head, and she showed clear signs of having been assayed. The medical team also found trauma to both the cervix and rectum, injuries that were caused by the forced insertion of foreign objects into her body. Additionally, genetic material was discovered both inside her private area and on her thigh, suggesting that sexual violence had occurred either before or after her death. The brutality she experienced was significant, marked by violent trauma, visible bite marks, and the kind of blunt force injury that suggested she had been stomped on. McGrath had been alive and conscious during large parts of the attack. Before the body was discovered, Jane Brand, an employee at Pace School, had noticed a suspicious man within the school's gated premises. When she confronted him and told him he needed to leave, the man quickly jumped over the fence and disappeared into the nearby alley. Curious and concerned, Brand looked into the alley and found McGrath's body. She later identified the man she had encountered on school grounds as none other than Thomas Goodinas. After Barbella's closed and everyone had returned to their apartment, all of Goodinas's roommates testified that he had not come back with them. Later, when they did see him again, they noticed what appeared to be fresh injuries, bloodstains on his underwear and scratches on his knuckles. When questioned about these wounds, Goodinas claimed that he had been in a physical altercation with 2 black men who had attempted to rob him. However, his story began to unravel. 2 of his roommates testified that when asked whether Michelle McGrath had been a good fuck, Goodinas chillingly responded, "I killed her, then I fucked her." Goodinas's violent history extended well beyond this tragic incident. In the early 1990s, during his time as a juvenile, he had already racked up multiple felony convictions in the state of Massachusetts. His criminal record included charges such as burglary of a vehicle, assault, theft, assault with intent to assay, indecent assault and battery, and assault and battery. On Tuesday, June 24, Goodinas, 51 years old, was put to death by lethal injection. At 6:13 p.m., he was declared deceased. Media observers claimed that the sound of an air conditioner interfered with his final statements, making them inaudible. Goodinas uttered a prayer of some kind, according to a prison spokesperson. He had pizza, fries, and soda for his last meal. Richard Gerald Jordan, June 25, Mississippi. Jordan, born on May 25, 1946, was incarcerated on death row in the state of Mississippi, having been convicted for the brutal murder of 34-year-old Edwina Martyr in 1976. Edwina was the wife of Charles Chuck Martyr, a prominent bank executive. From 2022, Jordan held the distinction of being the oldest living inmate on Mississippi's death row, as well as the individual who has spent the longest duration under a death sentence in the state's history. At the time of the crime, Jordan was experiencing a severe financial crisis. Unemployed and facing mounting financial stress, he began contemplating a criminal plan to obtain money through unlawful means. His desperation led him to conceive a scheme in which he would target a wealthy individual, specifically a bank executive, with the intent of extorting ransom money. To carry out his plan, he contacted Gulf National Bank located in Gulfport, Mississippi, posing as someone seeking a commercial loan. Through this ruse, he was able to learn the name of the bank's commercial loan officer, Chuck Martyr. Once he had this information, Jordan located Martyr's residential address using a local telephone directory. He then drove to the residence and abducted Edwina Martyr. Tragically, instead of keeping her alive for ransom purposes, Jordan transported her to the DeSoto National Forest and fatally shot her. Following this, he called Chuck Martyr in an attempt to extort ransom money by falsely claiming that Edwina was still alive. Initially, Jordan was found guilty in 1976 and sentenced to death. However, that verdict and the corresponding death sentence were later overturned due to a landmark decision that deemed automatic death sentences unconstitutional. Jordan was retried in 1977 and once again convicted and sentenced to death. He later appealed this second sentence, raising constitutional objections, and as a result, he was again sentenced to death following another trial. When the third death sentence was also overturned on appeal, prosecutors offered Jordan a plea agreement. According to the terms of this deal, he would plead guilty in exchange for a sentence of life imprisonment without the possibility of parole, and in doing so, he would waive all future rights to appeal. Jordan accepted the terms of this plea bargain, but he subsequently violated the agreement by filing an appeal against his sentence. In his appeal, he argued that a sentence of life without parole was unconstitutional in his specific case because, at the time of the crime in 1976, Mississippi law did not provide for such a sentencing option. Instead, he sought to have his sentence reduced to life with the possibility of parole, which was an available punishment under Mississippi's sentencing laws at the time of his offense. While the courts ultimately found the original plea agreement to be invalid, they did not grant his request for parole eligibility. Instead, a new sentencing hearing was ordered. This hearing took place in 1998, and at the conclusion of that proceeding, Jordan was again sentenced to death. Richard Jordan was born in Hattiesburg, Mississippi, to Mr. and Mrs. Homer Jordan. He spent his childhood in the nearby town of Petal, Mississippi. People who knew him during his youth and school years would later describe him as someone with a generally good reputation. After completing his education at Petal High School, Jordan enlisted in the U.S. Army, where he served for a period of 4 to 5 years, including active duty during the Vietnam War. By the mid-1970s, Jordan was married and the father of 3 children. Following his honorable discharge from military service, he found employment in Louisiana, while his wife and children remained in Hattiesburg. Jordan managed a fertilizer plant for about a year and also worked for a couple of months at a shipyard in Morgan City, Louisiana. By January of 1976, Jordan found himself in a state of dire financial distress. Faced with multiple debts and unable to make ends meet, he devised a desperate plan to kidnap a member of a wealthy family and demand ransom in exchange for their safe return. With this goal in mind, he set his sights on Gulfport, Mississippi, as the location where he would carry out his plan. On his way out of Louisiana, Jordan stopped at a pawn shop located at Baton Rouge, where he traded in his 16-gauge shotgun for a 38 caliber revolver. To his family, he lied, telling them that he was heading out to take a physical examination as part of the application process for a job of an offshore oil rig. Once in Gulfport, Jordan spent a few days familiarizing himself with the city and observing his surroundings. Then he set his plan into motion. On January 12, 1976, Jordan drove to the Martyr residence where he posed as a utility worker from the electric company who needed to inspect the home's circuit breakers. Under this false pretense, he was able to convince Edwina Martyr to allow him access. He then abducted her from the home, leaving behind the couple's 3-year-old child, who was asleep inside. At the time of the abduction, Chuck Martyr was away at work and the couple's older son, who was 9 years old, was attending catechism class. After kidnapping Edwina, Jordan forced her to drive with him into the remote and heavily wooded DeSoto National Forest. At some point after exiting the vehicle, he shot her once in the head, killing her. Jordan claimed that he only fired his weapon after Edwina attempted to flee and that he had meant to fire a warning shot above her head. In contrast, the prosecution argued that the evidence, including forensic analysis, indicated that Edwina had been kneeling and was shot at close range. Following the murder, Jordan went to a local movie theater where he watched the film Death Wish, a vigilante crime drama. Afterwards, he contacted Chuck Martyr and demanded a ransom of $50,000, falsely asserting that Edwina was still alive. Later that evening, the two men spoke again and agreed on a specific location for the ransom drop. That night, Chuck Martyr went to the designated site with law enforcement officers discreetly following him. Jordan, who was observing the location from a distance in the DeSoto National Forest, immediately detected the police presence and suspected a setup. The next day, he called Martyr again, accused him of trying to trick him, and offered an alternative ransom plan, this time demanding only $25,000. He instructed Martyr to take a convoluted route to the drop site, making numerous turns before getting on the highway to shake off any possible police surveillance. On the morning of January 13, at approximately 9 a.m., Martyr left the cache at a predetermined location near the intersection of Interstate 10 and Canal Road in Gulfport. An FBI agent and a deputy from the Harrison County Sheriff's Office were stationed nearby, concealed in a pickup truck, waiting to apprehend Jordan. When Jordan arrived to retrieve the money, the officers sprang into action. Jordan rammed the sheriff's vehicle into a ditch and sped away, ignoring gunfire directed at his car. One of the deputies involved in this failed apprehension attempt was Larkin Smith, who would later rise to political prominence, serving as both the Harrison County Sheriff and eventually a U.S. congressman. Despite initially escaping the authorities and abandoning his car, Jordan was eventually located. Around 1 p.m. that same day, a Gulfport police officer spotted him inside the taxi. He was arrested without further incident, and the majority of the ransom money was recovered. During police questioning, Jordan confessed to having murdered Edwina and led authorities to both her body and the murder weapon. During a subsequent psychiatric evaluation, Jordan told a mental health professional he had not acted alone, that an accomplice had actually shot Edwina and fled the scene before Jordan attempted the ransom scheme. However, this account was inconsistent with earlier statements, and Jordan's defense team ultimately chose not to use it in court due to concerns over its reliability. In July 1976, Jordan stood trial for the crimes of kidnapping and capital murder. Due to the extensive media coverage and concerns about finding an unbiased jury in Harrison County, a change of venue was granted and the trial was moved to Jackson County. It took place in Pascagoula, with jury selection beginning on July 19. The trial lasted 3 days. The prosecution presented a total of 24 witnesses, while the defense chose not to call any. After 4 hours of deliberation, the jury returned a guilty verdict for capital murder on July 21. When asked by the judge whether he had anything to say before sentencing, Jordan declined to speak. At the time, Mississippi law mandated an automatic death sentence for capital murder convictions, and that was the sentence Jordan received. However, a case was already pending before the Mississippi Supreme Court that was widely expected to declare such automatic sentences unconstitutional. Anticipating this legal shift, District Attorney Albert Nakase and Assistant District Attorney Joe Sam Owen considered requesting a separate sentencing hearing, but found no legal basis under state law to support such a motion. That same year, the U.S. Supreme Court ruled that automatic death sentences did indeed violate the Eighth Amendment's prohibition against cruel and unusual punishment. As a result, Jordan was granted a new trial. His second trial began on February 28, 1977, again in Pascagoula. This time, the trial was bifurcated, with separate proceedings for determining guilt and, if necessary, sentencing. Jordan was once again convicted of murder on March 2, 1977. The sentencing phase took place on the same day. defense attorney Earl Denham addressed the jury, stating that Jordan had been a good and decent man until around the age of 30, at which point something inexplicable changed in him. Denham described Jordan as mentally ill and incapable of understanding his actions. The defense presented several character witnesses, including Jordan's parents and a prison chaplain who had spent over a year praying with Jordan. The prosecution cross-examined the chaplain but called no new witnesses of their own. During deliberations, one juror initially opposed the death penalty. Denham and co-counsel Rhett Russell requested a mistrial, but the judge denied the motion. Eventually, the jury unanimously agreed to impose the death sentence. In the early 1980s, Jordan's attorneys challenged his sentence on the grounds that the jury had not received adequate instructions regarding how to determine whether aggravating circumstances applied. During closing arguments, Prosecutor Owen had told jurors that they had to individually decide what constituted an aggravating circumstance, without offering clear legal definitions. In 1982, the Fifth Circuit Court of Appeals ruled that the jury had not been properly instructed, citing the need for objective standards. The court overturned Jordan's sentence and ordered a new sentencing hearing. In the spring of 1983, shortly before this hearing, Denham withdrew from the case. Joseph Hudson, a Gulfport attorney, was appointed to represent Jordan, assisted by Earl Stegall. Although Owen had since moved into private practice, he agreed to serve as a special prosecutor for the hearing at the martyr family's request. Jordan testified that he had been financially overwhelmed and desperate, owing money for a car, a boat, and several department store credit accounts. His defense team called witnesses to vouch for his character, including prison guards and family members. The prosecution presented forensic evidence suggesting Edwina was stationary when she was shot. They also introduced a recording of Jordan admitting that he had formulated the ransom plot before seeking legitimate employment. Once again, Jordan was sentenced to death. He would later challenge this third death sentence on the grounds that he was denied the opportunity to introduce mitigating evidence, specifically testimony from Rhett Russell about Jordan's good behavior in prison and the creative invention he had worked on involving wind tunnel-generated electricity. The Mississippi Supreme Court rejected this appeal, ruling the testimony to be inadmissible hearsay. However, the U.S. Supreme Court disagreed, reversed the sentence, and remanded the case for a new hearing. In 1991, prosecutors offered Jordan a plea deal to avoid a fourth sentencing trial. He would receive life without parole if he agreed never to challenge the sentence again. Jordan accepted. However, the resolution would not hold. Years later, Jordan filed a federal habeas corpus petition in which he challenged the legality of his sentence. He argued that life without parole was not a lawful sentence at the time of his crime in 1976 and therefore could not be applied retroactively to him. The federal court agreed, finding that the sentence was indeed unconstitutional in his case. Although the court did not grant Jordan's request to be resentenced to life with parole, it did vacate the sentence and return the case to the state for another resentencing. At this point, Mississippi prosecutors, frustrated by the repeated appeals and reversals, decided to pursue the death penalty once more. Jordan's legal team accused the state of prosecutorial vindictiveness, essentially punishing him for exercising his legal right to challenge his sentence. They contended that the prosecution had only sought the death penalty again as retaliation for Jordan's appeal in violation of his constitutional rights. The courts, however, ultimately ruled that there was no clear evidence of prosecutorial vindictiveness and allowed the state to proceed with seeking the death penalty. In April 1998, Jordan faced his fourth sentencing hearing. The trial was held in Harrison County. This time, the jury was given clear and constitutionally sound instructions regarding aggravating and mitigating circumstances. After considering the evidence, the jury returned yet another death sentence. Since that time, Jordan remained on Mississippi's death row, where he continued to pursue various legal appeals. He challenged both the constitutionality of his death sentence and the state's method of execution. One of his most recent and significant claims involved Mississippi's lethal injection protocol. Jordan's attorneys argued that the state's current execution method, which includes the use of midazolam, a sedative that has been the subject of multiple legal controversies, could result in severe pain and suffering, thus violating the Eighth Amendment's prohibition on cruel and unusual punishment. In addition to challenging the method of execution, Jordan repeatedly raised the issue of prosecutorial vindictiveness. Despite these arguments, the courts have consistently ruled against him. In 2022, Jordan became the oldest and longest-serving death row inmate in Mississippi. His case has been cited frequently by legal scholars and capital punishment critics as an example of the flaws and inconsistencies in the American death penalty system. Over nearly 5 decades, Jordan has been sentenced to death 4 separate times and has spent almost 50 years navigating the legal system. On June 25, he was executed by lethal injection. His last words were, "First, I would like to thank everyone for a humane way of doing this. I want to apologize to the victim's family. I will see you on the other side, all of you." Jordan was served his final meal of chicken tenders, French fries, strawberry ice cream, and a root beer float at 4 p.m. local time. As of today, June 26, there is only one scheduled execution for the month of July, that of Michael Bell in Florida. Thank you for watching, and as always, stay informed, stay curious, and take care.